This is Constitutional Law, Thursday, April 2nd, 2020. And remember, we're meeting on, our next meeting is Sunday um, at 5 o'clock on Zoom. And we'll be turning to the commerce cases, the first set of commerce cases. Remember, your briefs are due by 8 o'clock on Sunday morning. All right. The purpose of these remarks is to, and you should have the notes in front of you, is to give background for the case of McCulloch v. Maryland, which we'll discuss fully in class today. And so I'll cover Roman numeral 1, the Articles of Confederation, Roman numeral 2, the Convention and the Constitution, and how this leads to, in some ways, the greatest source of political tension and controversy and conflict in our constitutional system, which is the conflict between the power of the national government and the power of the state governments. We'll see why that tension is so prevalent, both in the theory and structure of the Constitution and in our national history. And then I'll make a few comments based on Chapter 1 of Amar's Constitutional Biography, Chapter 1 of it, which has some very insightful and astute comments. And we'll leave Article Roman numeral 4, which is the actual discussion of McCulloch and the implications in in Roman numeral 5. We'll discuss those in our class session later today. So the purpose of these remarks is to give background to how this issue of the conflict between the states and the nation became, in some ways, the central conflict of our constitutional system, and how that sets up the background for McCulloch v. Maryland. So Roman number 1 of the notes, if you have it in front of you, is the Articles of Confederation, and I want to go over the Articles because not only does it set up this great question or issue in conflict within the constitutional system, you'll see that you have to pay attention to the language of the Articles of Confederation, because, as you'll see, there are echoes of this language in parts of the Constitution, and you'll see that the meaning of the Articles of Confederation and some of the language in its articles is important to Maryland's interpretation of the Constitution in Articles of Confederation. To all whom these presents shall come, we, the undersigned delegates of the states affixed to our names, send greeting. Articles of Confederation and Perpetual Union, and I'm going to read the first 3 articles and then jump to Article 13. The Articles of Confederation had 13 articles. Can you tell me why? And then we'll make some comment on them. Articles of Confederation and Perpetual Union between the states of New Hampshire, Massachusetts Bay, Rhode Island, and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia. Article 1, the style, meaning the name, of this confederacy shall be the United States of America. Article 2, each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right, which is not by this confederation, and I'm going to accentuate for dramatic purposes the next word, expressly delegated to the United States in Congress assembled. As I said, there are echoes of the Articles of Confederation in the subsequent language of the Constitution, and as you're going to see, the echo of Article 2 in the Confederation, and the Articles of Confederation is the 10th Amendment in the Constitution. Article 3, the said states hereby severally enter into a firm league of friendship with each other, for their common defense, the security of their liberties, and their mutual and general welfare, binding themselves to assist each other against all force offered to or attacks made upon them, or any of them, on account of religion, sovereignty, trade, or any other pretense whatever. Now, note the content and the progress of these first 3 articles. it begins, obviously, the most important issue for the Articles is the maintenance and preservation of the sovereignty and power of the states within the system. Um, that's what comes first, and 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 then of course then the Articles, after getting that critical principle of state independence and sovereignty as the main nature of the system, then turns to the creation of the central agency of the Confederation, the Congress of the United States. Um, um, but note uh, uh, that word expressly in Article 2. We'll come back to that. This is Article 13. Every state shall abide by the determination of the United States in Congress assembled on all questions which by this Confederation are submitted to them. And the Articles of Confederation shall be inviolably observed by every state, and the Union shall be perpetual. Nor shall any alteration at any time hereafter be made in any of them, unless such alteration be agreed to in a Congress of the United States and be afterwards confirmed by the legislatures of every state. So, uh, uh, this is not our main issue, but note the concluding article in the article. It in some ways asks the states to be good to each other and to obey the the Congress. It's a firm league of friendship. But as you're going to see, one problem is that bond of friendship dissipated very rapidly in practical politics and nearly tore the nation apart, as we'll see. And moreover, when it came to obeying not only the Articles but the Executive Congress, the states essentially flipped the Articles themselves and the Congress the bird and said, "Up yours." Now, as we'll see, this very fact is what essentially lays the ground for the necessity of constitutional reform in the Constitutional Convention of 1787. And as Hamilton said in Federalist 22, this was the great defect of the Articles. He says, let us stop trying to reconcile contradictions. The problem with the Articles is it's a confederation, as its name tells you, and it's an insufficient means to the national existence of the country. Reading from the notes a little bit, the Constitutional Convention of 1787, in addition, in addressing the deficiencies of the Articles of Confederation, created a new kind of federalism. Again, when I teach this material in American government, the founding and the Constitutional Convention, I note that the Constitution creates three great novelties in human political history. In prior history, all governments were either huge nations or powerful imperia or consolidated tyrannies, whatever you want to call it, and or republics, which tended to be small, and or democracies. The Constitution, for the first time, creates a huge, diverse national republic. And the classical locus of the discussion of the nature of that new kind of republic is, of course, Madison's great essay, Federalist 10. The second great novelty also had to do with a prior either or in human history, which was all governments were either republicans or they were some kind of king, monarchy, empire with a strong executive branch. We're going to call it that. The Constitution, for the first time, blends those two together and creates a strong executive, um, uh, but based on a constitutional and republican order. So the presidency is in some ways the second great creative achievement of the Constitutional Convention. The third is the subject of our discussion and the issue implicit in McCulloch, and that is all governments prior to the U.S. Constitution were either confederations, that is to say, like the United Nations, in which the members of the Union of the United Nations are the sovereign nations of the world, and with a relatively weak and impotent, as we know, um, central agency. Or they were strong national governments, empires, or nations in which local units were essentially subordinate to or parts of the national government. The Constitution, for the first time, for reasons we'll see, creates a blend of a new kind of federalism, which doesn't leave sovereignty either in the national center or in the states, but divides it between them. So we'll see the problems with that. So to go back to the Constitutional Convention and this question. The Constitutional Convention of 1787, in addressing the deficiencies of the Articles of Confederation, created a new kind of federalism. The old Confederation was, well, pause, a confederation in which the members of the Union of the United States of America were the sovereign states. Even though each state, as we saw in the language of the Articles, pledged to obey the Congress of the Confederation and the Articles themselves, in reality they did not. Central government was an agent, an instrument of the sovereign states, and had no power to restrain the states' behavior. That's why Article 13 of the Articles asks the states to obey the Congress. This led to the sacrifice of the national good and would eventually have led to the destruction of the nation. I think that's all observers of American politics, essentially by the time of 1787, saw what was coming. And the 55 members of the Federal Convention all were more or less convinced that this aspect of the Articles needed some kind of correction. The members of the convention, on the top of the second page of the notes for today, came to the realization that only a national government with substantial national powers, armed with enforcement powers to compel the states to obey, could secure the nation's common good. But no one at the convention, even Hamilton, although scholars debate this, wanted to actually eliminate the states as states or to reduce them to provinces or counties of the national government. It's true, Hamilton's plan went pretty far. I mean, he had the national governor or president appointing the governors of the states, and had the national executive had the power to veto state legislation. So, but nevertheless, everyone at the convention, certainly the majority, wanted to preserve the vibrancy and importance of the states in the Union. So, what did they do? They created a new compromise and a very messy and tension-ridden system which divides sovereignty, if that's possible, between a powerful national government and semi-sovereign states, partially sovereign states. Now, again, the moment you try to pronounce that feature of our system, you should hear the problems inherent in it, and those are exactly the problems that led to McCulloch v. Maryland. And I'll point out, are still being fought out. I mean, this tension is embedded in our system, and take even the question of national health care, Obamacare. We're going to read the case in which the court upheld the constitutionality of Obamacare this coming week. But you'll see that was essentially a question of the proper scope of the national government's powers in the constitutional system. So, what's the obvious problem in the question? How do you avoid clashes? Would a general principle work? And initially, Madison in the Virginia Plan and the New Jersey Plan, in the first part of the convention, they thought, well, maybe if we just state it as a principle, that the national government will have the power to achieve those purposes to which the states are incompetent in their individual existence. But they realized that was pretty vague, and that really didn't solve much. So, in essence, there are two core dimensions to the Confederation's embrace of this messy, divided of federalism. One, they opted out for a national government with structural residua, with residual elements of a confederation. For instance, the Senate, and that was the great compromise on July 16th in the convention, where the bicameral proposed Congress, and in the Virginia Plan, Madison's plan, both houses of the legislature in the Virginia Plan, the first plan of the convention, would have had proportional representation, and of course the small states. Most of you know this aspect of the convention. Small states resisted that. In the New Jersey Plan, they offered a reforming of the Articles of Confederation, and that was abandoned. But then ultimately, the struggle between the small and large states led to the Great Compromise in July 16th. So that's why the Senate has equal representation, because it's the states as states which are represented in the Senate, and each state, no matter its population, has an equal vote. Also, the Electoral College, which essentially federalizes the presidential election by causing it to occur state by state. Since the Electoral College is something of a misnomer, in reality, there are today 51 electoral colleges that select the president and vice president. In Article 4, which we looked at, by the way, for Luther v. Borden and the whole Republican guarantee in that, because Article 4 sets the relations between the states, like extradition, comity, recognition of each other's laws and documents, fugitive slaves, and of course the Republican guarantee principle that we saw in Article 4, Section 4. And to some degree, Article 5, the amendment, because the system can be changed and it's essentially a state by state. If you look at Article 5, Congress can propose amendments, or the states can call a convention to propose amendments, but the ratification of amendments is a state by state affair. And as we'll see, the really controversial question is Article 7, the ratification. More about that in a minute, and that's where Amar's first chapter is very insightful. So aside from those structural elements of maintaining aspects of a confederal system within the national government, the other primary way that they tried to achieve this divided sovereignty was Article 1, Section 8, the enumeration of powers. Combined eventually, by the way, after the ratification of the convention and the Constitution coming into power, with the first 10 amendments, the Bill of Rights, including the 10th Amendment, which, of course, is that echo of Article 2, the article that we said. We'll come back to that. This is, by the way, why if you look at most state constitutions, there's no enumeration of powers. There's nothing in state constitutions that corresponds to Article 1, Section 8, because the legislative powers of the states are not enumerated. They're not granted. They are recognized by the Constitution. And as we'll see, part of what the debate in McCulloch is what does the 10th Amendment mean? So here, to restate this issue so that you can hear the tension even better, is at the same time the Constitution creates, empowers, and limits the national government because it lists its powers, it also declares it supreme over the states, as in Article 6, the Supremacy Clause, which we looked at in Cooper v. Aaron. Just to remind you, in Article 6 it says, this Constitution and all laws of the United States, in pursuance thereof, and all treaties of the United States, shall be the supreme law of the land, and anything in any state, constitution, or government notwithstanding shall be void. All right. So, as we'll see, let's turn to the Amar's commentary on the nature of the new union. And the question in chapter 1 of Amar's book is what did the Constitution actually change in the transition from the Confederation to the Constitution? Aside from the general praise of the democratic nature of the Constitution and its ratification process, he rather poignantly argues that the ratification of the Constitution, the drafting and ratification, was the most democratic political event in the history of the human race up to that point in time. And we'll see part of the ground of his argument for that. But he kind of playfully states the question, after all, what was the name of the country before the Constitution? The United States of America. What was the name of the country after the Constitution? The United States of America. So same country, same name. But as you're going to see, and the essence of this is his argument that, we'll turn to the preamble in a minute, that the Constitution doesn't create a more perfect union. It creates a new kind of union. It recreates the country and actually creates for the first time an American people and an American national government. So let me return to my notes. So Amar's first astute, since I like it, I praised it, first chapter of his book on the Constitution is a meditation on the preamble and argues, as I just said, the Constitution not only creates a more perfect union, but a different kind of union with the American people as the new members of the new union of the nation, as opposed to the sovereign states. And as I mentioned in class, both American government and in other of my classes in this class, in a way, the Confederate States of America recognized this because when they drafted their new Constitution in February of 1860, which almost is verbatim the same as the U.S. Constitution, it was interesting that in the preamble they felt it necessary to reinsert this principle of state sovereignty because the Confederate Constitution says, "We, the people of the Confederate States of America, in the sovereign states assembled." Um, it's a different kind of union, and the new members of the union are the American people, the individual Americans that make up the American people. Um, but what about, and here's the main question, this is what the Confederates, in some ways, and you're going to see Maryland, in McCulloch v. Maryland, kind of fasten on. But wasn't the ratification procedure of the Constitution in Article 7 a confederal procedure, state by state? No. Remember, I read Article 13 of the Articles of Confederation, and there it's explicit, by the way. Any change to the whole system, this only becomes valid when all 13 states ratify it, and you can only change it when all 13 states unanimously agree to it. That's clearly a confederal a confederation because only the states comprise the union, constitute the union, and only the states can change it. Now, Article 7 of the Constitution says this Constitution will be ratified when conventions in 9 of the 13 states ratify it. So, wasn't the Constitution ratified by each state, and therefore did the Constitution simply leave the Confederation in place? Amar says yes and no. Amar argues that in Article 7, that Article 7 does not join a state to a state in a confederation. And this is the key of his chapter, and I'm persuaded by his account of this and his reasoning. Rather, it's not that when the ratifying convention in a state ratified the Constitution, that the one state then joined to another state, but that the people of each state were joined to the people of another state to create a new people. So, and now we can't go fully into that. His argument turns on his interpretation of what the special conventions were. Remember, in the Articles, it was the state legislatures, which represented the sovereignty of the states, that ratified any changes in the Articles themselves. The framers of the Constitution bypassed the state legislatures and handed over the ratification to special conventions for that purpose. And most of the states, by the way, those convention members were elected by the people. Again, I'm not going to go fully into this, but look in his chapter as to why he thinks that the conventions, the special ratifying conventions, were in fact, like, to use a term, the virtual people of that state. So when I teach American government, I try to have students imagine like one amoeba joining to another. When an amoeba joins to another amoeba, it's not like two amoebas holding hands. If amoebas had hands, those poor things, but they become a new amoeba, one larger. That's what Amar argues, and I think he's right about this. So when Delaware ratified the convention, and Pennsylvania, which were the first states in December of 1787 to do so, after the Congress received the Constitution from the convention and passed it on to the states. Again, what Amar argues is that the people of Delaware ratified the convention, and when the people of Pennsylvania did, they in fact became a new people, and that as the people of each state, the American people then came to include those people. Which is, by the way, why Amar argues, and I think he's correct about this, that the Confederate States were wrong and that Lincoln was right in claiming that he possessed the authority by virtue of his oath of office to use military force to compel a state to remain in the Union. This is a complicated argument. In my presidency class, we talk about this. But what Lincoln claimed, by the way, was the president has this unique oath of office. I do solemnly swear that I will execute the office of the President of the United States and to the best of my ability will preserve, protect, and defend the Constitution of the United States. Lincoln argued that the Constitution created a new national union, and that union was embodied in the Constitution. And if you allowed in principle each state government to secede unilaterally from the Union, you were allowing the state government to destroy the American people, the American nation. And since the president is obligated to preserve the Constitution, which can't exist unless there's an American nation, the preamble says, "We, the people of the United States." Therefore, Lincoln argued that he had the power to use military force to stop a state government from, in effect, destroying the American people through unilateral secession. Okay. Now, you'll see this is relevant to Marshall's arguments in McCulloch. So this great tension lay and lies still at the heart of our constitutional order. It has been the source of every major political controversy in the United States. When I teach American government, I say, every major political controversy and issue in American political life revolves around the concept of rights, which is true, points back to the Declaration. But every political controversy has almost always surfaced as an issue of what might be called state rights or the contesting the power of the national government. As you're going to see, it was the oldest controversy under the Constitution, which led to McCulloch v. Maryland, the question of the national bank. More about that in a minute. And but also the Civil War. This is the only constitutional question that led to the death of over 700,000 Americans. And it was implicit in the civil rights struggle, the New Deal, and healthcare, and to some degree, even as the coronavirus unfolds. One great question is how much is it the responsibility of the national government or the responsibility of the states and governors and the localities to address this crisis? As I said, as my notes say, this first surfaced in the first great partisan controversy, and in fact, it was the question of the creation of the national bank in the 1790s, the first national bank under the Washington administration, penned by Alexander Hamilton. That's what actually led to the creation of political parties. So, and again, when I teach American government, I point out to students that in some ways the core difference between the Democratic and the Republican Party today is whether they want to expand the powers and influence of the national government to secure the rights of individual Americans, or to preserve and restore or reinforce the powers of the states within the system, etc. So not only did this lead to the first great partisan controversy, it led to the first great court case regarding the nature of the constitutional system, besides, of course, Marbury v. Madison. And it's not as if there weren't other important constitutional law questions. But in some ways, McCulloch v. Maryland in 1819 really cemented, this is the point I'm going to argue, cemented the understanding of the Constitution as a supreme and powerful national government, which is at the basis, by the way, of Lamar's interpretation in Chapter 1. So I'll finish in about 5 minutes then, just laying out the actual background that leads to the conflict, and then we'll resume later on today with our class session discussing the case. So here's the background. Alexander Hamilton, who was clearly a nationalist, by the way, and was the Secretary of Treasury under President Washington, proposed the creation of a national bank of the United States. And Thomas Jefferson, the Secretary of State under President Washington, opposed that, argued against it. Washington adopted Hamilton's plan. It was proposed to Congress, and James Madison, who was a member of the House of Representatives, one of the 11 members of the Constitutional Convention who were sitting in the first Congress, and he was a representative from Virginia, and he argued against the constitutionality. Jefferson and he agreed. And you'll see, by the way, that Maryland's arguments in McCulloch v. Maryland are essentially a re-echoing of Jefferson's and Madison's arguments in the controversy of the first bank. The first bank was created. It was hated. It was controversial. The opposition to the bank and to other Hamiltonian policies in the Washington administration led to the opposition party of the Republican, or sometimes called the Democratic Republican Party, and of course the great victory of the Republican Party and the destruction of the Federalist Party in the election of 1800, with the election of Thomas Jefferson and the Republican Congress, most of the Republican governors, and the Federalist Party all but disappeared. And it wasn't until the 1830s that another kind of bipolar two-party system emerged. The reason that's a little ironic is of course Jefferson served his 2 terms, and then the um, fourth president of the United States was, of course, James Madison, elected in 1808. Now, part of the implication of the Republican victory in 1800 was the allowing of the charter of the first bank to expire. So hated was it. But after the War of 1812 and the burning of the Capitol and the revelation of the financial and otherwise impotence of the Madison administration, Madison changed his mind and came to see the necessity of a national bank of the United States. So in 1816, Madison proposed, and the Republican Congress agreed to the creation of the second bank of the United States. And that is the institution that led to the controversy in McCulloch. So the bank is created, and the first branch of the national bank is established in Baltimore, which happens to be in the state of Maryland. And so how did this lead to the clash of the controversies in the parties? The people of Maryland and the Republican administration of the state of Maryland so hated the bank that they passed a tax on all banknotes not issued by any bank, or a tax on all banknotes from any bank not incorporated by the state of Maryland. There was only one bank in the state of Maryland not incorporated by the state of Maryland, and that was the branch bank of the National Bank in Baltimore. And of course, the purpose of this was to economically destroy the bank by putting a tax on all its notes and transactions. Of course, it would render those bank loans and notes and everything more economically expensive and therefore the purpose of the tax was, in fact, to destroy the national bank. McCulloch was the principal officer of the bank, and the tax, by the way, was enforceable by a fine, and McCulloch refused to pay the fine. So how did this become the Supreme Court case of McCulloch v. Maryland? Because McCulloch was taken to court by the state and lost in the Baltimore County Court. It was appealed up to the Supreme Court, the Court of Appeals of Maryland, and of course, McCulloch lost there. And therefore, that's why the name of this case in 1819 is McCulloch v. Maryland. And that's where we'll resume our discussion later on today.